Memo bibia akwaba eba Melodies TV so. And then I'm going to say a year 28th of May 2024. Na and then ye him say NDC4 ebeye omo press conference na omo release statement a omo katre yen a secret recording of Attorney General oka say yentwantro allegedly ento atofo sensonian fanchino na answer na NDC4 be release no some pro NPP media to say Asase Radio edin kind of stories bia aba betuja omo pese as a womo dani asem no eto NDC4 eso. Now I want us to go and read Asase Radio for omo nsem a womo ka the reason why they are saying say entrapment NDC4 and I say womo entrap Attorney General. Now this is the story. You see, ambulance case plots by Richard Jakpa to entrap Attorney General reviewed. Now I say Richard Jakpa, the man suspected to have recorded the Attorney General, is on trial with a former Deputy Finance Minister and minority leader Ato Forsen. I say Assassin News has uncovered what appears to be a deliberate plot to entrap the Attorney General and Minister of Justice Godfred Dame last April in the house of Supreme Court judge name withheld, who happens to be a very close relative of the accused person suspected to have secretly recorded the Attorney General. Into Otremwa, or say Omoko Supreme Court judge bifie as a Supreme Court judge, or Mr. Jakpai a relative. Into Omoko Supreme Court judge in fee, and ho NDC 4 years, a Omoko trape Attorney General. No. Now, as I see Radio 4 and Supreme Court judge, edin, but and there Amenemoka saying the MPP's organizer Nanabi Ababonti Ababebo Supreme Court judge nidin what say Yunu Kulendi. Okay, also I was saying Richard Jakpa, the man suspected to have recorded the Attorney General, is on trial with the former Deputy Minister of Finance and minority leader Kisel Atoforsen in the ambulance procurement trial with an alleged 2.3 million euros financial loss to the state. The facts available to Assassin News indicate that Mr. Yebo Adame was invited by a justice of the Supreme Court of Ghana to come to his house for a discussion. He obliged, as would be expected, but had no indication that Mr. Jakpa would show up there. Inti Assassin News for say Supreme Court judge and a free Godfred Dame eba ni fie say womra no monye meeting and Godfred Dame so tie because Supreme Court judge there na say ebuo nti tie no okoye no onim say ade ayede koye no. This is what Assassin Radio is alleging. No onim say Mr. Jakpa be de ebe piem wo ho. Now, was the invitation by Supreme Court judge? Was in the course of the conversation with the justice of the Supreme Court, the accused person, Mr. Jakpa, whom the judge had introduced as a cousin, came into the room. The judge inquired as to what was happening with the plea bargaining proposal submitted by the accused and whether the same could be accepted. So see, Events Attorney General no de wakwa kopie mo Supreme Court judge ni fie. Omodi nkomo na Mr. Jakpa be mu. Mr. Jakpa be mu na Supreme Court judge nka say, "Oh, Godfred Dame, Mr. Jakpa oni oye minia, oye me cousin. Na mate se wo ne no kra no, case be koso. Plea bargain no say na eko." And also this conversation happened shortly after the prosecution had closed their case and the trial judge against the submission of no case to answer by accused persons had ruled that there was indeed a case to answer and that Dr. Atuforsen and Jakpa should go ahead to open their defense. But Jakpa, who was allegedly wired, breaching the trust of his cousin, the judge, is said to have spoken in a way designed to commit the Attorney General to say something injurious. Inti afe asemwa Asase Radio can say, na Mr. Jakpa or record it. Yeka so bi eye wired na te se nipa ko na record and afi Asase Radio for sanso ka se Mr. Jakpa ba no Osheda kan kasa bi in a way bi a ebema Attorney General answers bi a wobema no ebeye te say the Attorney General no ye nipa boni ni. So this is baby as I see radio for the asem na fa no. To mo tre say Attorney General no de onye nipa boni. Now so Mr. Japan same bi a wokan ne questions bi a wokan ne senya wokasa ye bi no. E ma Attorney General ma answers bi a answer no uti a ebeye say say Attorney General ikra no onye nipa papa. Then I feel say audio ni ba ni etie kasa bi na ekwakoye ne say Attorney General ni papa as radio di kan ka Ghana for say Mr. Jakpa say ni odi kan kasa ya no nti no ma Attorney General answer in that way. That's what they are claiming. Also, however, our checks show that Attorney General limited his interventions to facts and evidence of the case he had presented in open court. The high-profile nature of the case, our checks show, has led to a lot of pressure being brought on the prosecution against the continuation of the trial. The Attorney General, from one check, has always remained firm, but has welcomed the option of plea bargaining once properly framed. On March 2023, Justice Efia Sewa Asare Butcher's Court ruled that a prima facie case had been made by the prosecution against all the accused persons and that they ought to open their defense. Mr. Jakpa subsequently applied for plea bargaining but was rejected for not being properly framed and asked for it to be resubmitted. The Attorney General at the said meeting with the Supreme Court judge about 6 weeks ago informed the judge about the circumstances that had led to a non-acceptance of the plea negotiations and indicated that it was essentially attributable to the strategies adopted by the accused persons. The reasons, according to the Attorney General, were as follows. Mr. Jakpa had indeed submitted a plea proposal to the Office of the Attorney General by letters dated 16th April, 27th April, 16th May, 30th May 2023. But the difficulty was that the letters only stated that Big C General LLC, a Dubai-based company, had heard about the dispute and was prepared to pay 2 million euros and take back the vehicles purporting to be ambulances. In consideration of this, Big C would request for the Republic to discontinue the case against all the accused persons. The Office of the Attorney General replied that Big C was not a party to the court case in Ghana and therefore a plea agreement whereby Big C would offer to pay the amount in question in settlement of the case was improper. The third accused subsequently wrote, improving the offer made. Inti senia asemo America no, se company a involved no, emra Attorney General ka say omo the case ne yesi, omo the yesi company a involved no ba be ka say no problem. Say ya same way nenda ba be dani asem kesi yesi ya. Sika no yebetua say 2 million euros inti na wo pese okoche Godfred Dame ene Jakpa ene nkrofo tumu a. Don't worry, you bet you 2 million. No, near Babe fire cars. Say cars no more same pa. You bet you 2 million near Babe fire cars na then. Ako. Now so Attorney General Etroka said that be all company ne ye ni wu ni asem. So their business ne ne Babe ye ni wu ni asem. Into the tina baby. Fausika too baby. Ni ndili with Attorney General Ato Forcing any Mr. Jakpa. It was said the first accused person, Kesel Ato Forcing, through his lawyers, also wrote a letter to the Attorney General dated 23 July 2023, stating that he had no objection to the proposals by the third accused. The Office of the Attorney General replied to the first accused, Ato Forcing's letter, and asked him to clarify whether by the letter he is to be understood as also making a plea request. The first accused lawyers replied that he should not be understood as making a plea request. As based on the above, the Attorney General wrote to the accused person stating that the third accused person's offer was not acceptable. Even after this, counsel for the accused persons, particularly the third accused, Mr. Jakpa, continued to engage the Attorney General both in court and out of court on the possibility of negotiating a plea agreement. It was say Emra company neutral letter neba ya Attorney General Eko trauma company ne said that be o de on fa ho nti no on kan case ne ho nti ne ye mfi wo no e ho na Ato Forcing ne so lawyers e ba be try be ka say oh ye de company ne nkrata wo mo atra ba no ye de ye ni insusuye bia efa ho. We don't object to it. And Attorney General sanso be trauma ato force and say what throw letter away mami and say wonso ato force no. You want a plea bargain ana? Because ato force nka say he wants a plea bargain bia and say wa admit say we guilty. Nti ho na ato force sanso throw letter. Ne lawyer say sanso throw letter ma Attorney General say dabi we are not asking for a plea bargain. Nti ho no na Godfred Dame be throw letter. Emma all the accused people our car say well company nin sema wo mode ba no mintie ati ase into I say after that ne kra no na Mr. Jakpa lawyers etai ene ono Godfred Dame ekasa omo pese omo negotiate a plea bargain no mo drop case no especially against Mr. Jakpa. To say the Supreme Court judge then asked whether it was possible for an opportunity for a settlement to be given to the third accused person, his cousin. Inti Godfred Dame so tremu say eno hunti kra na Supreme Court judge no efre no ba afi ho nini na ye plea bargain negotiations several plea bargain negotiations ekoso ti ho na Supreme Court judge no ka kire Godfred Dame say ye ntena se ne yenka ne yen settle ne yen person ya me nua no ono ye beyi na efri asem mu because me nua no me pese ye be chi na atum. Godfred Dame so side of the story no. But during the meeting, the third accused person who was secretly recording the meeting accused the Attorney General of being too difficult and that he had something against him, the third accused persons, and wanted to see him in jail. It wanted to see him jailed. It was say omoye meeting no. Still Godfred Dame bibia de bebe I was say that bibia de bebe o si wontie. Ena o say Mr. Jakpa katre Godfred Dame say aden na waso oden sa. I say wasem ye den, wasem ye twintwan dodo, wa ye twan dodo. I said there by force I person ye na wo chimi tum because me ye plea bargain, me ye say me si me tiaka o se dabi, me si say o se dabi. I say by force chia person wo chimi tum nti na wo ye sa de we. O say asema Mr. Asasi radio nsema mo kan no. Say asema Mr. Jakpa e kan ye no. I said the Attorney General stated categorically that in a case involving financial loss to the state, the focus is more on the public officials whose acts occasioned the alleged crime. Inti ya hwana say Attorney General no ekatre ne say say a case be near financial loss to the state won put there who third accused person put there nya na ya na ye ni eda also eye aban nipa inti in this case ato forcing boni ato forcing na ye eno inti kra ne ye pese ye chinitum na wo there asem we put there na nka ho put there won ka ho to say but Mr. Jakpa stated that the Attorney General was the main hindrance to the settlement effort and that the offer by the accused persons for plea bargaining was good and reasonable. He alleged that if the Attorney General was so inclined, the case would have been settled long ago. It was a record conversation. It goes on to say, unknown to the Attorney General, the whole conversation was being recorded. Our checks show that apart from telephone conversations, the third accused knew that he couldn't meet the Attorney General anywhere and secretly record him unless, as it happened in the house of a judge, that Attorney General respected and also knows as a good friend. Tomo Tremu said Mr. Jakpa plane ye no hu say Godfred Dame no ono Mr. Jakpa nin to me recording no say phone so kra na on to me recording and the sad dia on planning you so ono anebusie ni a oye Godfred Dame adamfo wasan so ye judge no use no non fa recording no nya den embum. To say the Attorney General assured the justice of the Supreme Court that he did not have a problem with any of the accused persons and that if plea bargaining was what they wanted, it was just for them to come clean and indicate unequivocally that they wanted the same. To say Hona Godfred Dame country judge no say ono de enya ade opese ochi nkrofo ni tumo ni omuni asembia na say ye plea bargain no mo pe a omombra mbeka say no kware ye di bone mumfa nye den enche yen. So say he stated that the situation whereby they shied away from categorically applying for plea bargaining and proposed to pay the cost of purchase of the ordinary vans purported to be ambulances, but would rather want to hide behind an entity which was not a party to the case was unacceptable. And so what Trump say plea bargaining ena mo pa mo fa mo ni munyi membra ma mo nkɔ company n'echi because company ne de ye ne omu ni asem it is ato force in plea bargaining na omra mehu me no nka se no kware mi di bone say ni say na meye mi ametu aka jai case no na Ghana fo hu ne say indeed ato force in oye kronfo ni enjai case no say ejapa ono nso mbra mo mo ko nkɔ company echi nti o say attorney general no ono na asem no and also the Attorney General said this because in the case of the first accused, for instance, he had pleaded with the Attorney General to stop prosecuting him when he came to the Attorney General's house to plead in the company of a senior member of parliament. Also, the Attorney General had told him that the only way he could compromise was for the first accused, together with the other accused person, to submit a plea bargaining proposal. In the one Godfred Dame Susu claiming say, ato forcing any MP penyin bi a wo susu so ye MP penyin e ba Godfred Dame fie e ba be pan ne chow say one drop case no ti Godfred Dame say e ho no ka tra to force say o pese me drop case na ye plea bargaining na Ghana fo hu ne say wo pa me chow etie for anti case no asase radio phone so a side of the story no any I don't know who you want to believe but montre mo your comment box ni mo. Today will be an interesting day. We will listen to the audios and then we will speak on it. Mutra mwa your comment box, Medase.